everyone. Welcome to Crime in Court. This is the Menendez brothers' Path to Freedom, and we are talking, obviously, about Erik and Lyle Menendez and their chance to potentially be freed. After the 1989 homicides of their parents, we know now, and it's pretty much unrefuted that they were severely maltreated their entire lives by their parents. And for whatever reason, the DA in this case has denied their experiences completely. So, if you're not familiar, this current DA, Nathan Hochman, he just came into the office December of last year. So, while this motion for resentencing took place, or it started with the previous administration, and then Nathan Hochman comes along and he's like, hold on, guys. I don't want the Menendez brothers having an opportunity for resentencing, even though they are the model citizens of like pretty much any prison system. So, we have a very biased, very uh, almost, he comes off very angry and biased when he talks about the Menendez brothers. So, and they've done some really shady kind of things, whereas, they were supposed to have a resentencing hearing, and the night before, all of a sudden, the DA's office is like, "Oh wait, we need to continue the hearing because we need more information," which they knew this information was happening with the risk assessment. So it just nothing that he says or does is genuine to me, and so I believe that there is some cause to potentially get him recused. Basically, the process is, and I don't want to spend too much time on this because this is a long document and we've got a lot to get through. But I just wanted to give you a brief overview in case you don't have the backstory and whatnot. But so this motion to recuse Nathan Hochman, the current DA of Los Angeles County, goes before, I believe, the AG of California, and they can actually like weigh in and say, yes, you can recuse that, or yes, I agree, you should recuse them. No, I don't have a position, or no, don't recuse them. They should stay on the case. So those are kind of the options that they can take, but ultimately it is up to Judge Jessic, who will be hearing oral arguments this Friday, May 9th, for this motion and Nathan Hochman's motion in response to this. So I'll read that in another video, but let us get started. I know that was kind of a long intro, but I wanted to make sure that you guys had a good background information on where we're at kind of in this process. So, this is the notice of motion and motion to disqualify district attorney. So, this is to attorney Nathan Hochman and his deputy Stephen Katz. Also on here is Attorney General Bob Bonta. Bonta is the one who can weigh in and decide if he wants to agree that he should be recused or not have a position. And then also it is copied to the Honorable Michael Jessic, Judge of the Superior Court. They say, please take note that on May 9th, 2025 at 9:30 or so, or as soon thereafter as the matter may be heard, defendants Erik Galen Menendez and Joseph Lyle Menendez, through counsel, will move the court for an order disqualifying the office of the district attorney and any of his deputies from participating in the resentencing proceedings scheduled in this case. This motion is brought under the constitutions of the United States and the state of California, as well as California Penal Code Section 1424, and is made on the grounds that absent recusal, a conflict of interest would render it likely that the defendants will receive neither a fair hearing nor fair treatment through all related proceedings. So basically, they're not going to get a fair hearing because this particular person is presiding over, or not, but he's overseeing this case. He needs to be removed. So the motion is based on the files and records of this case, on the attached exhibits and the attached memorandum of points and authorities, and on such further evidence or argument as may be presented at or before the hearing on this motion. Pursuant to Section 1424, defendants request that the district attorney's office be recused. I know I speak really fast, so if you guys ever need to slow me down, you always can. There's the little settings on the icon that you can go to and change the speed. I'm a fast talker, so I try to slow it down when I think of it. So, pursuant to Section 1424, defendants request that the district attorney's office be recused. In the alternative, defendants request an evidentiary hearing. The witnesses defendants intend to present at the evidentiary hearing include their cousin, Anna Maria Baralt, another cousin, Tamara Goodall, Nathan Hochman, and Kathleen Cady. So Nathan Hochman himself, they want to call at an evidentiary hearing to get some testimony on the record from him. Memorand and Kathleen Cady obviously is the, or maybe not obvious to you guys if you're not familiar with the case. So Kathleen Cady is the attorney who represented Milton Anderson. Milton Anderson was one of the very few members of the family who denied that there was any kind of maltreatment going on in the house, and basically tried to sue the brothers after the first trial, and also testified for the state in favor of the death penalty for their own nephews. So there were two uncles, I believe, and Milton Anderson was one of them. Kathleen Cady was the attorney representing Milton Anderson up until his recent passing. So there are no longer any people on this planet that are family member victims that want to see the brothers remain in prison. Every single family member wants them to be released. But that particular attorney, Kathleen Cady, was obviously, put in positions of authority. She's the victim's advocate, or she's on like some victims advocate board, whatever. He basically promoted her and demoted or fired attorneys that were in the office prior to him arriving and having any kind of support for the Menendez brothers resentencing. So, but we'll get into that. So let's get started. We've got a lot of stuff to read through. So, introduction. After initial hung juries, Erik and Lyle Menendez were convicted of murder in the shooting deaths of their parents, Kitty and Jose Menendez. The matter is now before the court for resentencing. By now, the court is well aware of the major dispute between the parties as to the actual resentencing. From the defense perspective, both defendants have long admitted the shooting. So they've always admitted to it. Well, okay, let me not say always. They have admitted to it. Well, actually, Erik admitted to it, and that's why they're caught. But they have admitted to it for the longest time. Once it was, once it came out in the investigation that they were the ones that did it, then they always fessed up to it. But they did lie about it up until then. So they have contended that the offense was not the M word, but manslaughter committed out of fear based on a lifetime of physical and SA. So we have to say, shortened versions of things, and we can't say certain words on YouTube. So unfortunately, we have to use code. At trial, they testified in graphic details to the SA, and the abuse was I'm like so scared to say corroborated, like Hank Brennan. So every time I come up on corroborated, it scares me because I don't want to sound like Hank Brennan in the Karen Reed trial. So I apologize. So the abuse was corroborated by Kitty's niece, Diane Vandermolen. Lyle told her about the abuse when he was only 8 years old, pleading for help. It was corroborated by Jose's nephew, Andy Cano. Erik told him about the abuse when Erik was 12 or 13 years old. If he corroborated by prosecution witness It was also corroborated by prosecution witness Donovan Goodrow. Goodrow admitted that well before the shooting, Lyle told him that he and Erik had been essayed by their father. It was corroborated by Kitty and Jose's nieces, Kathy Simonton and Diane Vandermolen, along with their nephew, Brian Anderson. He's Junior. There was a Brian Anderson who's a brother of Kitty, and then there's Brian Anderson Jr. So he would have been the one that corroborated the testimony or the evidence that there were things happening in that house. All three testified to the extraordinary hallway rule, which we've talked about in depth here, that Jose demanded and Kitty enforced in the Menendez brothers. It was corroborated by Lyle's ninth grade essay about child essay. So the hallway rule, in case you forgot, anyone who, if Jose was in either of the brothers' rooms, no one, and I mean no one, was allowed to go down that hall, and Kitty enforced that and made sure that no one went down that hall. In light of their record of rehabilitation during their 35 years in custody, including achievements for the prison community, strides in education, consistent programming, disciplinary records, the views of prison officials, and both their demonstrated remorse for the crimes and the uniform view of the victim's family, including the surviving siblings of Jose and Kitty Menendez, resentencing is proper. The district attorney has a very different view. In the prosecution's view, there was no essay at all. They just deny it outright. Resentencing is not appropriate because although defendants have admitted the shootings for decades, they continue to maintain, as they have since trial, that they have been essayed since they were children. Under the district attorney's view, there can be no rehabilitation unless defendants not only admit the shooting, but disclaim the corroborated history of essay, which caused the first juries to reach verdicts evenly split between the M word and manslaughter. But in this other case, twin, an inmate need not agree or adopt the official version of a crime in order to demonstrate insight and remorse. In Palermo and Jackson, okay, so they're citing a bunch of other sites that also agree with that sentiment. The stark dispute between these two positions is for another day, the actual resentencing. The question this motion asks the court to resolve is whether Los Angeles District Attorney's Office should be disqualified from further litigating this case. As discussed below, this requires the court to ask two questions. One, does the record show a conflict of interest? And two, if so, is the conflict is if the conflict is so severe as to disqualify the district attorney from acting. As also discussed below, the answer to both questions is yes, because the record shows a conflict that renders it unlikely Erik and Lyle can receive a fair resentencing hearing. Recusal is proper. Moving on to statement of facts. The district attorney meets with the Menendez family members and requests resentencing. On October 3rd, 2024, Los Angeles District Attorney George Gascon, the original DA uh, that filed the motion for resentencing, said he announced that he was considering a request for resentencing in the cases of Erik and Lyle Menendez. That's according to Court TV News. On October 16th, 2024, 20 family members of Jose and Kitty Menendez came to Los Angeles to meet with representatives of the district attorney's office. In accord with Marcy's Law, they were met with representatives of the district attorney's Department of Victim Services. In addition, they met with Deputy District Attorney Nancy Theberge, in charge of the resentencing unit, and Deputy District Attorney Brock Lunsford, Assistant Head Deputy of the Post Conviction and Litigation Unit. These 20 family members came from all over the country, from New Jersey, Illinois, Pennsylvania, Arizona, Nevada, Washington, and Colorado. They included Kitty's older sister, Joan Vandermolen, as well as numerous nieces and nephews of both Jose and Kitty. These family members shared their consistent view that nearly 35 years in prison was enough, and Erik and Lyle should indeed be resentenced. The meeting lasted more than 2 hours. On October 23rd, 2024, private attorney Kathleen Cady stepped into the fray, filing what she called an application to file an amicus brief and amicus curiae brief regarding the habeas claim and any potential resentencing petition declaration of Kathleen Cady. We will read through that. We have that as an exhibit. We have all of these exhibits. Some of them we've already been through. The ones that we have not been through already, we're going to go over on in this stream. Some of the other ones were like parts of other motions, so they're just exhibits again to, reiterate what they're trying to say in this motion. So, all right, so Ms. Cady was representing Milton Anderson, Kitty Menendez's brother. According to Ms. Cady's filing, and in contrast to Joan Vandermolen, Kitty Menendez's older sister, Teresa Beralt, Jose Menendez's sister, and all of Kitty and Jose Menendez's other family members, Mr. Anderson opposed resentencing. So, all, as opposed to everybody else in the family, he's the only one that opposed resentencing. The next day, on October 24th, 2024, the district attorney filed a 56-page motion requesting 1172.1 recall of resentence and requesting hearing, signed by Ms. Theberge and Mr. Lunsford. Those are the two attorneys that felt retaliated against. They have their own lawsuits against the DA's office for being retaliated against for supporting this resentencing. In a section of this motion addressing Marsy's Law, this request accurately informed the court that 1. All but one member of the Menendez family supported resentencing, many of whom had met with the district attorney's office, and 2. One member, Milton Anderson, opposed resentencing but had declined the district attorney's invitation to meet, instead electing to communicate his views through counsel Kathleen Cady. The district attorney filed an amended motion on November 7th, 2024. Mr. Hochman wins the election, fires Nancy Theberge, transfers Brock Lunsford after he refuses to join the team, and appoints Kathleen Cady as the head of Victim Services. Weeks later, at the November 5th, 2024 election, Nathan Hochman defeated Mr. Gascon. As the new district attorney recently noted, this electoral victory gave him the unfettered, quote, right to assign the administrative staff of his choosing. Oh boy, Nathan Hochman has an ego, doesn't he? Which he did. Only 3 days after being sworn in, he fired Ms. Theberge, sending her to the county alternate public defender's office. Days later, veteran prosecutor Lunsford, who had never received even a single poor performance review in his 24-year career as a prosecutor, was stripped of all of his supervisory roles and transferred to the Norwalk courthouse as a calendar attorney. Basically, a huge demotion and a kind of a walk of shame, like to be demoted to that office. It's pretty much, that's actually where Pamela Bazanich, the original prosecutor in the first trial of the Menendez brothers. See, I talk so fast, I just go Mendez. Um, of the Menendez brothers. Pam Bazanich, after she basically lost the case because it was a mistrial, she was sent to that same office. as, I don't know, punishment or embarrassment, whatever it is. So, in a carefully worded footnote, the new district attorney now admits that before transferring Mr. Lunsford, he met with him and asked if he, Lunsford, wanted to review the original Menendez resentencing motion. He had a co signed, and if so, he could join the team. Lunsford could join the team. When Mr. Lunsford made clear he did not wish to change his position, the offer to, quote, join the team was apparently rescinded and the transfer to Norwalk was finalized. All the careful phrasing in the world cannot disguise what was really going on. Mr. Lunsford had failed the litmus test required to, quote, join the team. So it was off to Norwalk with him. But the new district attorney did not just wield the power to fire, he also wielded the power to hire. Thus, the office needed a lawyer to head the Office of Victim Services. In a December 13th, 2024 interview, Mr. Hochman admitted that he had already spoken with Kathleen Cady, the lawyer representing Milton Anderson, the only family member to oppose resentencing. Less than 2 weeks later, it was Ms. Cady who Mr. Hochman selected to be the new head of the Department of Victim Services. And we have a footnote here that says the sharply contrasting fates of Theberge and Lunsford on the one hand and Cady on the other are not the only assignments of administrative staff, suggesting the importance of a particular view as to the Menendez case. Thus, Deputy District Attorney John Lewin is a vocal critic of the Menendez brothers, publicly and repeatedly voicing his opinion as he was free to do. After Mr. Hochman was elected, he promoted Mr. Lewin to the Major Crimes Division and rewarded Lewin with a six-figure settlement of his lawsuit on day one of the Hochman reign. Doing the hard work apparently pays off, and that's a dig at Nathan Hochman saying, because he was basically, as soon as he was elected, he was like, yeah, I'm going to do all the hard work. I'm going to really look into this case. No, you're not. You had no intention of even supporting anything that had to do with Menendez. Kathy Cady and the district attorney both recognized the conflict of interest. To her credit, Kathleen Cady recognized there was a conflict of interest in one, working on the Menendez case, two, heading up the Department of Victim Services, and at the same time, three, representing one of the victims. She filed a notice of withdrawal as attorney of record for Mr. Menendez. We will read that. Mr. Hochman is also to be credited. His office properly recognized the conflict and on the record assured this court that Ms. Cady had been walled off from the Menendez case. Has she? I don't think so. Mr. Hochman was equally reassuring in many of the press conferences and interviews he did about this case, repeating the refrain, Ms. Cady had been walled off from the case. Ms. Cady had been walled off from the participation or contact with the Menendez case. These are quotes from Nathan Hochman. Ms. Cady has been walled off from any involvement. Hochman said Friday that Ms. Cady has been walled off from the Menendez case. If the court grants an evidentiary hearing as requested, we may learn how this ethical wall was designed to work. As discussed below, what we know from the actual practice is that 1, the family members who Ms. Cady did not represent were deprived of any victim support services from the district attorney at all. 2, absent any constraints from the Department of Victim Services, the district attorney proceeded to ignore explicit victims' rights obligations imposed by both Marcy's Law and his own legal policy manual. And 3, after defense counsel objected to the district attorney's treatment of the family victims, Ms. Cady and Mr. Hochman appeared together at a victims' rights gathering sponsored by a group called Justice for Homicide Victims, a group of which Kathleen Cady is a board member, where the group condemned the Menendez brothers' resentencing. Special Directive 24 24/5, and the Legal Policy Manual. The day the new district attorney was sworn in, he issued Special Directive 24/5 to restore the Los Angeles County District Attorney's Office Legal Policies Manual in effect on December 6, 2020. The LPM, the Policies Manual, provides, quote, deputies shall be sensitive to the concerns of victims and the families in all cases. Deputies shall be especially sensitive to the emotional needs and problems of families of homicide victims. That includes the Menendez family members. Deputies should refer victims to the Bureau of Victim Services. Did they do that in this case? No. District attorney personnel should take protective measures to prevent the insensitive handling of photos. It is our responsibility that when victims participate in the criminal justice system, they are not caused undue emotional stress or emotional trauma, harassment, or embarrassment. Examples include the unnecessary dissemination of distressing photos, which the deputy DA did in a hearing earlier in the month of April. So, in a hearing, he flashed pictures. It was their they had a hearing to withdraw the resentencing motion. That's where this took place. They flashed photos of the gruesome crime scene and didn't tell the victims, and sent one of the elderly aunts to the hospital a few days later due to the stress of it all. In a section of the manual entitled Respect and Dignity, the LPM alerts prosecutors about the impact on victims of evidence from cases, especially gruesome crime scene photos, and advises that when feasible, victims should be contacted and advised before sensitive materials are made public in court. The LPM mirrors and gives voice to requirements set forth in Marsy's Law. That law provides victims with a number of rights set forth in the Constitution, including the right to 1, be treated with fairness and respect and to be free from intimidation, harassment, and abuse, and to 2, reasonable notice of all post-conviction release proceedings, including those gruesome crime scenes. To be sure, as the court itself observed at the April 17th hearing, it is important to note that this case presents a wrinkle. It is quite apparent that the views of the family as to continued punishment do not align with the views of the new district attorney. Instead, they are a full 180 degrees apart. The court's observation was spot on. But it is equally important to note that nothing in Marsy's Law says the district attorney's obligation to treat victims with fairness and respect applies only to victims who march in lockstep with the district attorney's views on crime and punishment. So just because they don't receive Marsy's Law only if they agree with the DA. The DA is supposed to enforce Marsy's Law on all victims equally. And nothing in the district attorney's own LPM says that only victims who agree with the elected district attorney on issues of punishment are entitled to the respect and dignity owed victims, the prosecutor's special sensitivity to victims in homicide cases, or notice before distressing crime scene photos are present in public. As the district attorney's new Department of Victim Services head noted in publicly calling for Mr. Gascon to be defeated in the 2024 election, advocates from the DA's Victim Services Department are essential in guiding victims through the criminal justice system, offering them support and helping them heal. But not in this case. On April 3rd, 2025, Mr. Hochman met with a group of more than 20 family members. There were 5 members of the DA's office present for all or part of the meeting: Nathan Hochman, Steve Katz, Seth Carmack, Habib Balian, and Ethan Mullius. In contrast to the family's October meeting with the office, there was no one there from Victim Services. In a civil complaint filed with the Civil Rights Section of the United States Attorney's Office, one of the victims, Tamara Goodell, made clear what occurred at this meeting. And we're going to read her entire declaration when we get to the exhibits. In a tear filled meeting, she says, numerous family members shared the ongoing trauma and suffering we have endured for more than 30 years. Instead of responding with compassion, acknowledgement, or support, DA Hochman proceeded to verbally and emotionally re traumatize the family by shaming us for allegedly not listening to his public press briefings. His hostile, dismissive, and patronizing tone created an intimidating and bullying atmosphere, leaving us, the victims, more distressed and feeling humiliated. Ms. Goodall explained that rather than focusing on the trauma and concerns expressed by the family, D.A. Hochman shifted the meeting's focus onto himself, making it a lecture on how he was being personally treated. What a douchebag. After the family meeting, Ms. Goodell and her 14-year-old son, Lucius, had a private meeting with the district attorney along with Mark Garagos and Brian Friedman. When Ms. Goodall shared her concern about impartiality giving Ms. Katie's appointment, concerns Mr. Hochman himself recognized in walling off Ms. Katie, Mr. Hochman became visibly agitated, dismissive, and aggressive and questioned what Ms. Goodall knew about Kathy Katie's prior work. Why'd you get so defensive there, buddy? Given that both Ms. Katie and Mr. Hochman have properly recognized the conflict caused by Ms. Katie's appointment to head the Victim Services Department, this reaction was surprising. The conflict is so obvious that a question from a concerned member of the family about the conflict is neither insulting nor out of bounds. According to Ms. Goodall, Mr. Hochman accused her of lambasting Ms. Katie in the press, and when advised that Ms. Goodall had done no such thing, Mr. Hochman said he was really talking about others in the room, adding that Mark Garagos represented horrible people. Mr. Hochman explained that Ms. Goodall was welcome to refuse any assistance from Victim Services. Although Ms. Katie was to be walled off in the months since the January 3rd meeting, no one from the District Attorney's Victim Services Department has contacted even a single one of the family members whose views conflicted with the views of Ms. Katie's former client, meaning Milton. So no one from Victim Services has assisted with the notices of court appearances or logistics. As the court is aware, there were 16 family members on the witness list for the April 17th resentencing coming from all parts of the country. No one from Ms. Katie's Department of Victim Services informed even a single one of these family witnesses that on the afternoon of April 16th, the day before the hearing, the district attorney had moved for a continuance. The treatment the victim's family has received from Victim Services under Ms. Katie's leadership is starkly inconsistent with the treatment they received prior to from the prior administration. Erik and Lyle will be clear. They do not fault the line deputies for seeking a continuance on April 16th, given that they learned of the basis for their request the day before. The difficulty is that Ms. Katie's Department of Victim Services elected not to alert either the victims traveling from across the country or their counsel. So it's not the issue that they did the continuance, even though it was kind of crappy that they did it the night before, but they didn't give ample warning, and they didn't give any warning to the victims, that especially those that were coming from out of town to attend that resentencing hearing that had to be continued to a later date. Now it still hasn't been rescheduled to my knowledge. They're trying to recuse Nathan Hochman first. This comes first. And from what happened at the April 11th hearing, the court is also aware that the LPMs expressed concern about sensitivity to family members of homicide victims and the importance of advance notice when distressing crime scene photographs are displayed was honored more in the breach than in the observance. With no warning to the many family members sitting in the courtroom, the DA displayed gruesome crime scene photographs on several occasions. To be sure, notwithstanding the narrow legal issue presented to the court for resolution on April 11th, Erik and Lyle recognized that the parties may have legitimate, good faith disagreements as to the relevance of such photographs to that issue. Counsel from both sides expressed those disagreements at the April 11th hearing. That is to be expected in an adversary system. Sorry. But there should be no disagreement that even if the family members differ with the newly elected DA as to the matter of continued punishment, they are still victims. They still lost family members, and they are still entitled to the respect and consideration aspired to in the LPM. Although counsel for Erik and Lyle do not represent the victims, they objected during the April 11th proceedings to the surprise presentation of those photographs without warning to the family. With good reason, as it turns out. On the evening of April 11th, after the photographs had been displayed, it became clear that Jose Menendez's 85-year-old sister, Teresa Baralt, had been in the courtroom, had never seen the photographs before, and was traumatized. The next day, Saturday, Ms. Baralt was found unresponsive and rushed to the intensive care. I'm sorry, it was Saturday. I thought it was Sunday, but no, it was Saturday, so it was the very next day after the hearing. We have a footnote that says, as of the writing of this motion, undersigned counsel has been notified that Miss Baralt is recovering. It is unclear, however, if she will be coming back to court. All right, the ethical wall. In addition to being the new head of the Department of Victim Services, walled-off attorney Kathleen Cady is also a board member for the Victims' Rights Group, Justice for Children whose lives have been taken. The group was founded by LaWanda Hawkins. On Sunday, April 13th, the day after Ms. Baralt was hospitalized, Ms. Hawkins' group held a rally. Press was there. So were both Ms. Cady and Mr. Hochman posing together for photos. And we have photographs included. In fact, in an April 10th Facebook post, Ms. Hawkins had announced Mr. Hochman as one of the featured speakers. Erik and Lyle recognized that although Ms. Cady is a board member of the organization, the mere fact that Mr. Hochman was speaking does not in and of itself suggest a breach in the ethical wall prohibiting Ms. Cady from assisting on the case. But it turns out this was not just another gathering of the victims' rights groups. As the headline in the day's news story notes, in that day's news story notes, crime victim advocacy groups gather in San Pedro to condemn the Menendez brothers' resentencing. So they literally met just to rally against resentencing for the brothers. The DA's office did. Like, that just doesn't seem right. It's so like, you shouldn't have a game in the fight. You should be in it for justice, not for, keeping people locked up and holding rallies. You shouldn't be in rallies at all. Whatever. So the article goes on to note that some of the participants, including founder LaWanda Hawkins, used the time to share how the resentencing of the Menendez brothers would undermine justice for crime victims. In short, number one, Ms. Hawkins founded Justice for Children whose lives have been taken. Ms. Cady is on the board of that same organization. Ms. Cady represented Milton Anderson, who was opposed to the Menendez resentencing. Ms. Cady and Mr. Hochman, along with press, were present at the April 13th rally, and 5, the rally condemned the Menendez brothers' resentencing. There are, of course, two possibilities. First, the focus of the rally to condemn the Menendez brothers' resentencing and Ms. Hawkins' statements to that effect were simply a coincidence and the ethical wall remained intact. Coincidences don't really exist, but say more. Or second, the focus of the rally was not just a coincidence, and the ethical wall prohibiting Ms. Cady from assisting in this case has crumbled. Summary. So here is where we are. Mr. Hochman fired Nancy TheBurge He transferred Brock Lunsford to Norwalk after deciding that he could not join the team. He hired Kathleen Cady to the team and made her head of victim services. He and Ms. Cady have both recognized the conflict in her hiring. The district attorney maintains he has been walled off from this case. But since her appointment, the family members who had views different from Ms. Cady's former client had received no victim services at all from the department. They have been met with what they perceive as hostility when they met with the district attorney, and one of the matriarchs of the family has been hospitalized after the district attorney ignored his own policy about exposing victims to gruesome crime scene photographs without warning. Moreover, a victim advocacy group on which Ms. Cady serves as a board member arranged for Mr. Hochman to appear at a rally which condemned the Menendez brothers' resentencing. In evaluating the impact of Mr. Hochman's decision to appoint Ms. Cady as Director of Victim Services on his ability to exercise discretion in a fair manner, a quick review of her amicus brief is useful. The amicus brief contains a statement of facts without a single citation to the record. It contains a reference to unnamed sources unsupported by any declaration filed under penalty of perjury about fraud, alleging that one of the pieces of new evidence on which the habeas petition relies, which is the letter from Erik to his cousin Andy Cano, was written in the last few years. That's what she wrote in the amicus brief with no actual knowledge to be able to state that. And they uh, refute it and say this is a serious allegation. To check this allegation, all Miss Cady would have to do was log onto YouTube. It turns out that in a television special aired a decade ago, November 2015, Barbara Walters explains that this same letter was given to her by Andy Cano's mother, and Ms. Walters then shows the letter on screen. Ms. Cady's entirely unsupported allegation of recent fabrication simply ignores that the same letter was actually shown on air in 2025. The application is ridiculed with similarly inadmissible, unattributed, and unreliable hearsay. So, Kathy Cady's amicus brief, which we will read through, is a bunch of malarkey. Argument. The district attorney's actions in this case decision show a reasonable possibility the office may not exercise its discretion in an even-handed manner, and recusal is therefore proper. The standards governing a motion to recuse. A defendant's motion to recuse a district attorney is governed by Penal Code Section 1424. That section contains both procedural and substantive provisions. In terms of procedure, Section 1424, Subdivision A, requires a defendant seeking recusal to file a notice of motion, which shall contain a statement of the facts setting forth the grounds for the claimed disqualification and the legal authorities relied upon by the moving party. The district attorney may file a written response, and the court must then determine whether or not an evidentiary hearing is necessary. When a defendant's papers, including affidavits and exhibits, establish a prima facie case for recusal, that is, if the defendant's affidavits, if credible, would require recusal, the court may hold an evidentiary to resolve any factual disputes between the parties. Basically, just hold a hearing so we can put evidence on the record and we can dispute it in a court of law. Section 1424 also sets forth the substantive standard to be applied in deciding whether recusal is required, providing the recusal is proper whenever the evidence shows that a conflict of interest exists that would render it unlikely that the defendant would receive a fair trial. Although motions to recuse a district attorney are most typically made in the context of an actual criminal prosecution, the broad language of Section 1424 does not limit its application to criminal cases. Instead, and by its own terms, the conflict of interest standard set forth in Section 1424 permits disqualification of a district attorney in connection with performing any authorized duty. In terms of the substantive standards, Section 1424 mandates two inquiries in connection with a recusal motion. One is there is a conflict of interest, and two, if so, is the conflict is so severe as to disqualify the district attorney from acting. As the Supreme Court has made clear under Section 1424, the conflict need not be actual. An appearance of conflict will be sufficient. The conflict inquiry is not overly technical. It asks whether the circumstances raise a reasonable possibility that the DA's office may not exercise its discretionary function in an even-handed manner. The second inquiry asks whether any such possibility is so great that it is more likely than not the defendant will be treated unfairly during some portion of the criminal proceedings. No one factor will compel disqualification of a prosecutor in all cases. Rather, the entire complex of facts must be reviewed to determine whether the conflict of interest makes fair and impartial treatment and the defendant unlikely. In applying Section 1424 and in deciding whether recusal of an entire office is proper, courts have recognized a clear distinction between conflicts impacting a line deputy and conflicts impacting the elected district attorney. Thus, it is generally true that the threshold necessary for recusing an entire office is higher than that for an individual prosecutor. But courts do not blink reality. Courts recognize the real world practicalities may require office-wide recusal when a potential conflict involves not just a line deputy prosecuting a case, but the elected district attorney with power to manage, hire, supervise, promote, and transfer employees of the office. Noting that where the attorney with the actual conflict has managerial, supervisory, supervisorial, why can I not say that word, and or policy making responsibilities in a public law office. It doesn't sound right. Supervisorial, something like that. It just doesn't sound right to me. Screening may not be sufficient to avoid vicarious disqualification of an entire office. In City and County of San Francisco versus Cobra Solutions, noting that where the conflict involves the elected district attorney, the attorneys who serve directly under him or her cannot be entirely insulated from real or perceived concerns as to what their boss wants. The power to review, hire, and fire is a potent one. People versus Choi, where conflict involves elected prosecutor recusal of entire office was warranted because of the potential bias that might result from the fact that prosecuting deputies are hired, evaluated, and promoted by the district attorney. People versus Lepe. So, there are three questions to be answered in connection with this motion. First, is there an actual or apparent conflict? That is, do the circumstances raise a reasonable possibility that the DA's office may not exercise its discretionary function in an even-handed manner? Second, if so, it is more likely than not the defendant will be treated unfairly during some portion of the criminal proceedings. Third, because the conflict here involves the elected district attorney and not simply a line duty or a line deputy, is recusal of the entire office required or may an ethical wall cure the problem? It is to these three questions defendants now turn. Because there is a reasonable possibility the district attorney may not exercise his discretionary function in an even-handed manner, and that defendants may be treated unfairly during the resentencing process, recusal is proper. The initial question, Section 1424, requires the court to answer is whether the circumstances raise a reasonable possibility that the DA's office may not exercise its discretionary function in an even-handed manner. The court will, in some point, at some point be addressing the district attorney's request for resentencing. In connection with the resentencing process, this district attorney certainly has great discretion in deciding not only when and how to meet with victims and what kind of victim support services to provide, and has equally great discretion in how much to credit the voices of victims in the resentencing process. Indeed, for years it was Ms. Katie herself criticizing Mr. Gascon for paying insufficient heed to the victims of crime. Having discharged Ms. Burge, having provided Mr. Lunsford with freeway therapy, that's what they call it by moving him to the demoted, like, uh, office that in Bufu that they don't want they don't want to hear from you ever again. It's like banishing you. Having elevated Ms. Katie, who represented Mr. Lunsford and opposed resentencing, to Director of Victim Services, having deprived the victims of victim services, there is a reasonable possibility that the DA's office may not exercise its discretionary function as to the remaining victims in an even-handed manner. But there is an additional problem. When a district attorney moves to recall a sentence, a trial court is charged with deciding two questions. One, whether to recall the sentence, and two, if so, what sentence to impose. As to the latter question, Penal Code Section 1172.1, Subdivision A3 gives the trial court discretion to reduce a defendant's term of imprisonment by modifying the sentence or vacate the defendant's conviction and impose judgment on any necessarily included lesser offense or lesser related offense with the concurrence of the defendant, and then resentence the defendant to a reduced term of imprisonment. In the original motion to recall sentence, the district attorney position was that the court should vacate the special circumstance finding and impose a 50-year to life term, one 25-year to life term for each of the homicide charges. At the resentencing hearing and based on the evidence to be presented there, Erik and Lyle will urge the court to impose a lesser sentence than special circumstances homicide, which should or could include either first-degree homicide without special circumstances, second-degree homicide, or manslaughter. Given that the Burge was fired and Lunsford transferred simply for seeking resentencing in the first instance, it is difficult to imagine any deputy district attorney giving fair consideration, either in settlement negotiations or in court, to evidence supporting in opposition or imposition of any of the lesser offenses. So basically, what they're saying is none of the other attorneys in the DA's office that could look at this case, they're not going to look at it objectively because their jobs could potentially be on the line, is what they're saying. So Hochman holds the power over everyone in that office. So you have to recuse the whole office. This leaves two remaining questions in assessing the need for recusal. Is it more likely than not the defendant will be treated unfairly during some portion of the criminal proceedings? And if so, since the conflict here involves at least Mr. Hochman himself, is recusal of the entire Los Angeles District Attorney required? Erik and Lyle will take these two questions together. Given the actions which have already occurred in this case, the answer to both questions is yes. In the uh, code, the code sets forth the factors that courts should consider in deciding whether to resentence. In their original 56-page request for resentencing, deputy district attorneys the Burge and Lunsford reviewed literally thousands of pages of material analyzing these factors in great detail. Thus, in accord with the code, focus on the focus on the disciplinary record and record of rehabilitation of the defendants while incarcerated. They discussed the remarkable evidence of rehabilitation for both Erik and Lyle. There is no need to repeat that evidence here. What is noteworthy is that the record of rehabilitation was also accomplished when the defendants were under a sentence of life without the possibility of parole, with no hope that such conduct could somehow inure to their benefit. Prison records show these achievements consist not only of personal achievements, education, programming, and work related, but they also include remarkable contributions to benefit the prison community. This is why the district attorney concluded that both Erik and Lyle have proven themselves to be incredible assets to their prison community. The district attorney was correct. Erik co-funded the Life Care and Hospice Connection program to provide support for disabled and elderly inmates. He founded of the Victim Impact and Victim Empathy for Vulnerable Populations, co-founded a 12 steps recovery and meditation program, and co-founded the Starlight Peace Project class. Lyle held significant leadership roles for more than a decade in the prison community. In that role, he fostered a positive programming culture at Mule Creek State Prison. He worked with inmates populations to build consensus to allow integrated housing without inmate pushback, and he created 4 new programs within the prison system to assist and better his fellow inmates' quality of life, including the Green Space program to beautify the prison, the rehabilitation through beautification, volunteer work group, the adverse childhood experience and rehabilitation program, and mentoring group for life without parole prisoners. So they have done a lot in their 35 years. But Miss DeBurge was fired from the office. Mr. Lunsford was transferred in an act of freeway therapy. The lawyer representing the one family member opposed to resentencing, a lawyer who, without ever noting that the evidence was broadcast on television a decade ago, has accused Erik and Lyle of recently fabricating the evidence for their state habeas petition, has been plucked from private practice and not just employed as a deputy district attorney, but elevated to director of victim services. Real sus. And although this lawyer was supposed to be walled off, the treatment the family has received since the change in administration and the April 13th rally suggests that the wall is porous at best. Sometimes actions speak louder than words. No lawyer employed by the Los Angeles County District Attorney's Office could misread these signs. If you want a career at the office to, quote, join the team, it is clear what position the team captain requires an attorney to take. And as noted above, courts have long recognized that this is a really good argument. I mean, really good to say, well, we know what Nathan Hochman's position is, so we pretty much know, like, yeah, you're gonna have to fall in line. And he's been known to being a bully, so maybe, he bullies his staff too. I don't know. And as noticed above, courts have long recognized that where the risk of unfair treatment arises at the very top of the district attorney's office, recusal of the entire office is required because the attorney who serve directly under him or her cannot be entirely insulated from real or perceived concerns as to what their boss wants. Power to review, hire, and fire is a potent one. Indeed, as noted above, the new district attorney himself concedes the point, maintaining that his election victory gives him free rein to hire and fire. So he doesn't give an F about that. He's just like, whatever, I'm going to do what I want. I'm Nathan Hochman. I'm in office and I will hire, fire, and resentence or not resentence whoever the heck I want because that's who he is. Erik and Lyle Menendez are entitled to a fair resentencing process. Jose and Kitty Menendez's family members, regardless of what position they take as to resentencing, are all entitled to a fair resentencing process. The public is entitled to a process that appears fair. Because the actions here raise a reasonable possibility that the DA's office may not exercise its discretionary function in an even handed manner, and there is a genuine risk that Eric and Lyle will be treated unfairly during some portion of the proceedings, recusal is required. In the People versus Cruikshank or something, Ms. Katie herself sought to disqualify the Los Angeles District Attorney from a criminal case because the office had manifested a fundamental inability to be fair to the victims in that case. In Ms. Katie's view, family victims have the specific right to expect elected officials to act in good faith, and Marcy's law includes a mechanism to move the court to remove a prosecuting agency which has flagrantly violated those rights. Here, too, the repeated violations of Marcy's law and the LPM and the likely breach of the ethical wall compel a similar result. The court should recuse the Los Angeles District Attorney's Office from this case. In the alternative, the court should grant an evidentiary hearing to explore whether either Ms. Katie or Mr. Hochman can be successfully walled off from the case. I love how these attorneys throw Hochman's own words back in his face in their legal writings, and it's beautiful. All right, there are a lot a lot of uh, attachments. We're not going to go through all of them. So up first, we'll go through a good portion of them, but we're not going to go through all of them. So up first, we have Exhibit A, which is the declaration of Mark Garagos, who is the brother's attorney. He says, I am a lawyer licensed to practice in California. I am co-counsel for Lyle and Erik Menendez in connection with their resentencing proceedings. On October 16th, 2024, I was present for a meeting at the district attorney's office and approximately 20 family members of Jose and Kitty Menendez. There were representatives of Department of Victim Services at the meeting as well, and Deputy District Attorneys Nancy Theberge and Brock Lunsford. These family members came from all over the country, including New Jersey, Illinois, Pennsylvania, Arizona, Nevada, Washington, and Colorado. Among the members to attend were Kitty Menendez's older sister, Joan Vandermolen, as well as numerous nieces and nephews of both Jose and Kitty. They shared their views that nearly 35 years in prison was enough and Erik and Lyle should indeed be resentenced. The meeting lasted more than 2 hours. I was also with the family on January 3rd, 2025, when they met with newly elected District Attorney Nathan Hochman. There were 5 members of the District Attorney's Office present for all or part of the meeting. That includes Nathan Hochman, Steve Katz, Seth Carmack, Habib Balian by telephone, and Ethan Mullius. There was no one there from Victim Services. I declare under penalty of perjury that the foregoing is true to the best of my knowledge and belief. Executed whatever day on April. I guess he forgot. That's the unsigned version that got attached somehow. Next is the application to file an amicus curiae brief regarding habeas claim and any potential resentencing petition declaration of Kathleen Katie. So this was referenced about her trying to file this amicus curiae brief, which is basically like I'm a disinterested party. I'm not the state or the defendant, but I have some information that can help you. So I'm going to write this brief and tell the court this is some information I have for you that could help you in deciding things in this case. That's kind of my interpretation of what an amicus curiae is. So anyone can write one. Doesn't mean that they're going to accept it, but it can go be filed on the docket. So, to the Honorable William C. Ryan, Judge of the Superior Court, George Gascon, Prosecutor, and Mark Garagos and Cliff Gardner, Counsel for Defendants/Petitioners. Kathleen Katie submits this application requesting permission to file an amicus curiae brief to assist the court by providing informed perspective of the homicide victim Kitty Menendez's brother, Milton Anderson, as well as relevant law regarding any pending habeas claim and or petition for resentencing. Although there is no clear authority for permitting an amicus curiae brief in the trial court, there is also no authority that precludes the court from allowing the filing of an amicus curiae brief if the court finds it helpful. Amicus curiae presentations assist the court by broadening its perspective on the issues raised by the parties. Among other services, they facilitate informed judicial consideration of a wide variety of information and points of view that may bear on important legal questions. Amicus curiae briefs in the trial court are permitted at the discretion of the court when the court feels that the amicus has something to add to the issue. A petition for habeas corpus relief was filed in May of 2023. If the district attorney in the county of conviction or the attorney general concedes or stipulates to a factual or legal basis for habeas relief, there shall be a presumption in favor of granting relief. This presumption may be overcome only if the record before the court contradicts the concession or stipulation, or it would lead to the court issuing an order contrary to the law. The elected district attorney has publicly stated that he is considering the habeas petition and is also potentially considering a resentencing petition. So this is George Gascon's office before they filed the habeas had been filed by the defense, but this was before they filed the resentencing petition. The media has reported that Gascon's office stated a decision would be made within the next 10 days of October 16th. Despite numerous requests on behalf of Milton Anderson to reasonably confer and to receive notice of any decision, the district attorney's office has not provided any substantive information or responded to the request to reasonably confer. This leaves Mr. Anderson in a difficult position of having no idea of how or what position Mr. Gascon intends to take on the habeas petition. What does it matter to him? I mean, regardless of what George Gascon's position is, it doesn't affect Mr. Anderson, really. I mean, not entirely. Mr. Anderson also does not know whether Mr. Gascon intends to file a resentencing petition or upon what code Mr. Gascon would rely for such resentencing petition. Whether or not he does or doesn't, like, okay, um, I understand you're a victim in the case, but you can't control what the DA is going to do. He's going to make a decision, and you're either going to like it or you're not going to like it. It has, Mr. Anderson really doesn't have much of a say. Same as, in the whole resentencing process, they could have said, no, we're not going to do it and never gone through with it. But you can't just take it back now. Anyway, this leaves Mr. Anderson in the untenable position of filing an amicus curiae brief for the court's consideration. California Rules of Court Rule 8.882D1 establishes the rules for filing an amicus curiae brief with the appellate court. Applicant's interest in the proceedings. Applicant's interest is to ensure that the court is aware of all facts before ruling on a habeas claim. The purpose of assistance of proposed amicus brief. The applicant seeks to have the court consider Mr. Anderson's objection to a concession of the habeas petition or to any resentencing petition. Authorship of the brief. Applicant's proposed brief was authored by signing counsel who is pro bono and has received no monetary contribution for preparation or submission of the brief. Based on the foregoing, Mr. Anderson respectfully requests that this application for permission to file a brief as amicus curiae be granted. And here is the brief. At approximately 10:30 p.m. on August 20th, 1989, Joseph Lyle Menendez and Erik Galen Menendez entered the den of their parents' home in Beverly Hills and fired shotguns multiple times, taking the lives of their parents, Jose and Kitty Menendez. The shotguns had been purchased 2 days earlier in San Diego by the defendants using false identification. At the time of the shooting, Jose and Kitty were unarmed, watching television and eating. That's a lie. They were not eating, they were actually standing, and they weren't sitting, relaxing, having a nice, relaxing evening like this was like they try to portray. But anywho, Jose suffered 4 gunshot blasts with buckshot ammunition. Kitty suffered 7 gunshot blasts with buckshot ammunition and 2 gunshot blasts with birdshot ammunition. And that has to do with the size of the pellets that are released from each of the uh, buckshot, I guess you call it, from each of the buckshots. So there's either, um, or sorry, buckshot is for like bigger game when you're hunting bigger game. So the pellets are bigger and there's less of them. Birdshot, you're hunting smaller game, so there's more smaller little pellets inside the shotgun shell. Lyle told an attorney and friend of the family that he thought his father might have changed his will and that those changes might be in the family computer. Lyle told witnesses that either the Colombian cartel or mafia were responsible for the homicides. Jose and Kitty's assets were valued at over $10 million. Erik and Lyle that's also not true. Total, uh, there were debts too, so I don't know what the actual total ended up being about, but anyways, I think that's a little high. Erik and Lyle each received over $325,000 in life insurance proceeds, but what they're failing to tell you is that that was from Marticano's insurance plan that she got for them, not anything that the parents got for the brothers. Eric and Lyle told the therapist that they took the lives of their father because they hated him and the homicide of his mother was a mercy killing. Two witnesses, Amir Aslam, those were also uh, his therapist's words, not Eric and Lyle's. Two witnesses, Amir Aslamania and Jamie Pisarcik, testified about efforts to fabricate evidence. Aslamania, a high school friend of Eric's from Beverly Hills High School, started visiting the brothers in jail. Lyle asked Aslamania to give testimony favorable to the defense, specifically to testify falsely that the day before the homicides, Lyle and Eric came to him and said that they needed a handgun for protection from their parents. Pisarcik was the other witness who testified that Lyle had asked her to give false testimony. In December 1990, Lyle asked her to testify that his father had done to her what had been done to a character in a movie called At Close Range. Pisarcik was familiar with this movie, having seen it with Lyle. In the movie, a man gives his son's girlfriend a sedative, then tells the girl to stop seeing his son. The girl refuses, and the father, she says violently, R's the girl. It's implied that he does something to her, but that's not in the movie exactly. I mean, it's implied. It cuts to another scene after like he starts tugging at her clothes or something. I don't know. I've never seen it, but the way that they're painting this scene is much more nefarious. I mean, it's not a great scene, but we don't even know if that's the scene. We're reading through Jamie Pisarcik's testimony right now, and her testimony is not very reliable, and neither is Eslaminia's, by the way. So in the movie, oh, I read that. The girl refuses, the father R's her. Lyle said Pisarcik had to do it because a large sum of money was to be placed in her bank account. Pisarcik said if money appeared in her account, she would tell the police. Eric testified at trial that his father had essayed him. Eric's cousin, Andy Cano, testified at trial that Eric told Cano that his father had been touching him in in an intimate manner. Neither mention anything about Eric having written Kano a letter that referenced this. Well, they probably forgot that this letter existed. Stupid. On March 20th, 1996, the jury found defendants guilty of 2 counts of homicide with a special circumstance of lying in wait and conspiracy to commit the homicides. On July 2nd, 1996, the trial court imposed consecutive terms of life without parole on the homicides and stayed the conspiracy sentence. On May 3rd, 2023, the defense filed a petition of habeas corpus claiming to have new evidence. Gascon is facing re-election. His opponent is Nathan Hochman. Do you think that this woman, Kathleen Katie, and Nathan Hochman might be in cahoots to perhaps um, help each other out politically? Maybe. Just saying. Seems like they have a very close relationship, and they get defensive if you maybe talk about the other one. On September 30th, 2024, NBC reported a recent survey showed Gascon trailing Hochman by 24 points. On October 3rd, 2024, the LA Times front page headline read, Teen KILLer's case haunts Gascon. This headline was later changed to Gascon gave teen KILLer second chance. Now she's charged again. On October 3rd, 2024, Gascon called a press conference. He made no announcement other than to say he was considering the habeas petition in the Menendez case and was also considering possible resentencing. On October 8th, 2024, at a recorded debate, when asked about the Menendez habeas and/or resentencing, Gascon said, "The decision will be mine." On October 14th, 2024, Mr. Anderson's attorney notified Mr. Gascon via email that Mr. Anderson was asserting and requesting all his constitutional and statutory rights. Included in the email was the following. Mr. Anderson specifically asserts his right to be treated with fairness and respect for his dignity, right to reasonably confer with you, reasonable notice of all public proceedings, and right to be heard regarding the sentence or post-conviction release decision. Because you have confirmed that you personally will be making the decision as to how to proceed, Mr. Anderson is asserting his right to meet with you personally to discuss this case and the decision that you have apparently made. Kitty Menendez's brutal homicide was not political. Jose Menendez's vicious homicide was not political. Erik and Lyle Menendez's motive was pure greed. Mr. Anderson demands that any decision you make not be political. He requests to confer with you immediately and hear your decision before you hold another press conference to announce your decision to the press and the general public. On October 16th, the following email was sent to Mr. Gascon. It says on October 16th at 9:30 a.m., I emailed Ms. TheBurge asking her to confirm that your office will provide notice before any action is taken in court. To date, I have not received a response. This morning, I filed the attached notice of appearance and assertion of rights to Judge Ryan's court and served you and defense. On October 15th at 2:50 p.m., Ms. TheBurge invited me and my client to attend a meeting on October 16th at 1:30 p.m. that was just scheduled. I informed her that I was unable to participate as I had a conflicting court appearance that had been scheduled for several weeks. The media has been reporting that as of Wednesday, October 16th, that you will make a decision about the case in the next 10 days. Although you have not responded to my October 14th email, Mr. Iniguez attempted to chastise me for making assumptions based on tabloid gossip, not official information from our office. We wait with anticipation for your office to provide information. Until that time, we have no alternative but to gather information from the tabloids since that appears to be your preferred method of communicating. Wow, this woman is a snarky little bitch, isn't she? The current habeas petition asserts a false narrative that the jury was precluded from hearing evidence of abuse at the second trial. The 2/27/1998 Court of Appeal opinion, however, confirms that substantial evidence of the alleged abuse was admitted at the second trial. In addition to Erik's testimony, several witnesses testified that Erik and or Lyle were abused. Any excluded evidence was determined to be cumulative. The jury also heard evidence that Lyle asked two witnesses to commit perjury. Amir Eslamania testified that Lyle asked him to lie and testify that the day before the homicides, the brothers told him they needed a handgun for protection from their parents, and Jamie Pizarczyk testified that Lyle needed her to lie and testify that Jose Menendez gave her a sedative and then violently arred her. The alleged new evidence, which is referenced in the habeas of the letter, is suspect because Erik and Andy Cano both testified to the second trial and neither mentioned the letter. Maybe they didn't realize it existed. It wasn't found until after both trials concluded and they had been sentenced. While we certainly hope that the DA's office has undertaken an analysis of the letter, it is much more likely that the letter, if written by Erik, was written in the last few years and not before the homicides, as the defense now suggests. So here's where she's saying it was just written in the last few years. This is her implying that they're lying about this. In just the last few days, I have received information from several different sources that the letter is essentially a fraud. Some of the people providing the information to me have informed me that they have made multiple efforts to get this information to you, but have been ignored. Additionally, even if legitimate, this new evidence is not sufficient to warrant granting the habeas because this evidence does not justify an imperfect self defense instruction. The evidence does not demonstrate that the brothers were in imminent peril when they took their parents' lives. Based on that, we urge you to oppose the habeas. It is unclear what type of resentencing you may be contemplating. Do you love how she's like putting all these words in quotes? It's pretty snarky. Snarky stuff. Of great concern is that the defendant's petitioners are still fabricating a fraud on you and the court. If that is true, they are certainly not rehabilitated. I have also received information that while in prison, the brothers have violated regulations and use cell phones for drug trafficking. What? Out of here. When did. No, that's not true. They have used cell phones. They've been caught with some regulation violations, but very, very minor stuff. What she's talking drug trafficking, what is she talking about? Again, this would demonstrate a complete lack of remorse and rehabilitation. Contrary to your public assertion that you will be handling this case on October 15th, Mr. Iniguez informed me the habeas matter is being handled by the Writs and Appeals Division. The review for potential resentencing is being handled by the resentencing unit. Please clarify which DDA is handling the habeas and or resentencing petition and whether you will be making the final decision. Mr. Anderson once again requests that you meet with him and provide notice of any upcoming hearing, filing, or decision before any public announcement is made or any information is leaked to the media. I mean, that's a fair. Some of these requests are fair. Like Mr. Anderson should know these things, but that doesn't mean that he has really, that he can change the law. If the brothers meet the resentencing requests or resentencing code, all the requirements, there's no reason why they need to be remaining in prison. It's no longer in the uh, it's no longer serving justice anymore if they remain there. Although Mr. Gascon has not responded to a request to meet with Kitty's brother, Milton Anderson, on October 21st, 2024, Gascon took the time to be interviewed by People. As reported in People, Gascon says he will make a decision on whether or not to recommend resentencing for Erik and Lyle Menendez in a matter of days, and that the brothers are not a danger to society. Based on everything that I know, I don't believe they are, Gascon tells People. Quite frankly, they probably haven't been for a very long time, if they ever were. I think this is not like they were going, it's not like they're going to, I think this is not like they were going around taking people's lives or robbing people on the street. And there's a link to that interview. On October 22nd, why can I not talk? On October 22nd, 2024, the following email inquiry was sent to the district attorney's office. To ensure my client constitutional rights are not violated, can you please respond to the following questions? What DDAs are or is assigned to review and consider a potential resentencing in this case? Under what code section is the potential resentencing being contemplated? Has a decision regarding resentencing been made? Can you confirm that we will receive notice of any decision before any statement is released or leaked to the media and or document filed with the court? Um, but what is this? Another set of questions. What DDAs are assigned to the habeas? Okay, so now this is for the habeas only. So, what DDAs are assigned to the habeas petition? I have received information casting doubt on the veracity of the new alleged evidence referenced in the habeas petition, given the DA's ethical obligation to fully investigate any and all claims. When should I expect someone to contact me about the information I have received? Has a decision regarding the habeas claim been made? Can you confirm that we will receive notice of any decision before any statement is released or leaked to the media? Blah, blah, blah. To date, we have not received responses to our inquiries or any substantive information on what decision Mr. Gascon may have made regarding this case. Points and authorities. Um, Hold on. I think I might skip this part. This is more like law stuff, but oh, okay. We're almost done. Never mind. Okay, so points and authorities. The alleged new evidence is not new and does not warrant granting an imperfect self-defense instruction. Given the defendant's attempts to suborn perjury, the new evidence should be viewed with skepticism, even at face value. However, the new evidence would not require an instruction on imperfect self-defense. Quoting from the 1998 Court of Appeal opinion at pages 109 to 110, Erik argues that the trial court's refusal to instruct on heat of passion was error. We disagree. The trial court determined that the evidence presented in the case did not justify the giving of the instruction. The evidence indicates the defendants, after initially shooting their parents, realizing that their mother was still alive, went out to Eric's car and reloaded Lyle's shotgun and went back into the residence to complete the act. Um, okay. The Ninth Circuit also evaluated the imperfect self defense claim and determined the instruction was not warranted under California law. Had either Erik or Lyle presented evidence that at the moment of the homicides they had an actual fear in the need to defend against imminent peril to life or great bodily injury, this evidence would have helped explain why they had that reasonable or why they had that unreasonable fear. Nonetheless, the fears leading up to the homicides and the reasons why such fears might have existed simply are not the threshold issue for the California's imperfect self-defense instruction. Consequently, the state court's decision was not error. Okay, but we're talking about something completely different, which is resentencing, which is doesn't have to do with imperfect self-defense. So, whatever. Uh, That doesn't, it doesn't equate. It doesn't match what we're arguing here. Should the district attorney's office concede any habeas claims, we ask the court to set the matter for an evidentiary hearing so the court can examine all the evidence to determine whether the claim should be granted. This is the penal code that they want, 1385.1, which precludes striking or dismissal of or dismissing a special circumstance allegation found true by a jury. Despite requests to learn under Penal Code section, Mr. Gascon may be contemplating regarding filing a resentencing petition, we have not been provided that with that information. Penal Code 1385 requires that any dismissal of charges or special circumstance allegations be in the interest of justice. Based on the horrific actions taken by Lyle Menendez and Erik Menendez on August 20th, 1989, which the jury determined was motivated by their desire to inherit their parents' fortune, Mr. Anderson believes that justice was served when the jury found Erik and Lyle guilty of multiple homicides for financial gain. They never said that. That was not the reason why. And the judge sentenced them to life without the possibility of parole. I mean, that is what the state argued, but I don't think that they proved that. And the grand jury took that out of the charges, so that it was never a charge. Declaration of Kathleen Cady. She is an attorney licensed to practice law in the state of California. She represents Milton Anderson, brother of Kitty, and she's pro bono and receives no compensation for representing Milton at this time. Los Angeles County District Attorney Gascon is facing re-election. His opponent is Nathan Hochman. On September 30th, 2024, NBC reported a recent study showed Gascon trailing Hochman by 24 points. On October 23rd, the LA Times front page headline read, Teen KILLers Case Haunts Gascon. On October 3rd, Gascon called a press conference. He made no announcement other than to say that he was considering the habeas petition in the Menendez case and was also considering possible resentencing. On October 8th, I attended a debate between Gascon and Hochman. When asked about the Menendez habeas and/or resentencing, Gascon said the decision will be mine. On October 14th, I notified Mr. Gascon via email that Mr. Anderson was asserting and requesting all his constitutional and statutory rights. Included in the email was the following. Mr. Anderson specifically asserts his rights to be treated with fairness and respect for his dignity, his right to reasonably confer with you, reasonable notice of all public proceedings, and right to be heard regarding the sentence or post-conviction release decision. Because you have confirmed that you personally will be making the decision as to how to proceed, Mr. Anderson is asserting his right to meet with you personally to discuss the case and the decision that you have apparently made. Kitty Menendez's Okay, we read all that already. She's just repeating herself now. Mr. Anderson demands that any decisions you make not be political. He requests to confer with you immediately and hear your decision before you hold another press conference to announce your decision to the press and the general public. On October 16th, 2024, I sent the following email to Mr. Gascon. That's basically the same thing that we already read. As reported in People, Gascon was interviewed by People October 21, 2024. The article reported Gascon says he will make a decision on whether or not to recommend resentencing for Erik and Lyle Menendez in the matter of days, and that the brothers are not a danger to society because, on everything that I know, I don't believe they are. Quite frankly, they probably haven't been for a long time, if they ever were. I think this is not like they were going around KILLing people or robbing people on the street. On October 22nd, I sent the following email. And that was her asking all those questions. To date, I have not received responses to my inquiries or any substantive information on what decision Mr. Gascon may have made regarding this decision. I declare under penalty of perjury under the laws of the state of California that the foregoing is correct and true. So there you have it. basically, I guess George Gascon is giving him the runaround too, like Nathan Hochman was with the family, the other victims of the family who support Eric and Lyle. So not cool if that's what he was doing. It sounds like he wasn't answering him, which someone from that office, whether Gascon or not, somebody should have been contacting him from victim services. But I don't know if that was happening or not. I can't say. So regardless, let's move on. Next filing that I want us to look at. I don't think we ever read through this. This is the Deadline article that they keep referring to in their filings, the Menendez brothers filing, keep referring to this. So let's actually read this. This is the Deadline article where Nathan Hochman was interviewed and said some things. So this was December 13th, 2024. New LADA, Nathan Hochman, so he just came into office, says Menendez brothers lawyers' narrative is absolutely wrong. Vows to enforce sanctuary laws against Trump. Okay, okay, brother. Up to the top floor of downtown's Hall of Justice, the Los Angeles District Attorney's Office has little of the grandeur that the rest of the nearly 100-year-old ornate building itself would suggest, as the newly sworn in Nathan Hochman himself points out. Quote, I wondered why all the windows were facing upwards, why they had what looks like bars on them, the former U.S. Assistant Attorney General says. I discovered this used to be the county jail before the building reopened in 2025. Hochman adds with a laugh, waving his arm around his own largely bare office, not far from where now dead Charles Manson and still living Suran were once incarcerated. Loves that case. Just a few days ago, into his term after a landslide victory over one-termer George Gascon, with support from Netflix's Ted Sarandos and Oscar-nominated documentarian Rory Kennedy, ex-Republican Hochman makes no secret of the fact he's trying to settle in quickly, figuratively, and literally. Yet, in a sprawling county larger and with a greater population than most states, no matter how fast he goes, time is not something Hochman has in abundance, as a thirst for change, a need for safety, and anger in incumbents was what turned so many Anglo- Angel Angelinos, right? That's how you say it, right? So many Angelinos against Gascon. Among one of the matters ticking away in Hochman's inbox is the revived case of the Menendez brothers. Convicted of first-degree homicide in the second trial in 1996 and sentenced to life without parole, the now middle-aged brothers' case was brought back into the courts by Gascon earlier this year or last year as newish evidence of SA by their father became known. In one of the most media driven towns on the planet, the siblings' 1989 homicides of their parents in the family's Beverly Hills home was also back in the spotlight over the past year by well watched shows on Peacock and Netflix. In the dying days of his regime, with a hopeful eye on the polls, Gascon recommended resentencing and even backed a plea for clemency for the brothers before Governor Gavin Newsom. With now DA Hochman diving into the particulars of the case, that's now all on hold until a January 30th hearing for 54-year-old Erik and 56-year-old Lyle Menendez. A hearing that likely won't see the duo free immediately, but could certainly see the two of them out of prison in the next year. At the same time as the Menendez case captures headlines and social media posts, Hochman faces other high profile cases, a depleted staff, getting his own team in place, Donald Trump's return to the White House with promises of mass deportations. Sitting in the casual conference area of his personal office, the new DA discussed all this with me, as well as challenges he faces inside and outside the building and the county. Deadline. How has the first week been in terms of learning the job and seeing what the full responsibilities of the job are? Hochman says, I view the first week like I've used the first day, or even the anticipation of the first day as an opportunity of a lifetime. I'll get a chance, and I've been now exploring it at its fullest extent of working with some of the most diverse and talented lawyers in the legal profession, not just as prosecutors. Part of that is I will be visiting the staff, visiting the prosecutors in the 15 different offices we have. I'll be talking with law enforcement, eventually talking with probation officers, to judges, even talking with public defenders and alternate public defenders. Look, the system is broken. The system I came into just isn't working. This office wasn't working. How so? Huckman says, it lost 20% of its workforce in recent years. People who just stopped believing in that the DA was on mission and they just as soon leave to find some other jobs or retire. And now it's a sense of, I don't know if it's the word relief as much as it's hope. I find a sense of energy when I go talk to people that they just fired up to get going with the job. I hear you with that, says Deadline, or the interviewer with Deadline. But that's inside baseball to most. Regardless of where one stands on the political spectrum, there are a lot of people in LA County who can't get any real response from a 911 call, who see justice as being very selective. And to be honest, the extremes have overwhelmed real dialogue and they feel they've been abandoned. Hochman says, unfortunately, it's not a shock that people feel that way because the feeling is based in reality. Deadline. Certainly, people whose families have suffered tragic or fatal consequences from crime, like Netflix CEO Ted Sarandos, one of your biggest supporters in the campaign, know that feeling strongly. Then what do you, and I mean you, what do you do about that? Hochman says, what I say to that is that part of striking the right balance is having the right set of procedures and the right DA in place. Deadline says, which is what? Hochman. If a DA came in and said, instead of decarceration, we're now going to emphasize mass incarceration again, if they said, we want to send a message to the criminal element that we're just going to put them in jail, literally, until we get the courts telling us that we put too many people in jail. I'm telling you, I reject that. I reject both extremes. I reject extreme policies. I come down in the middle. I call it the hard work middle. Does he? I've never seen him be in the middle of the road on this at all. Or the hard middle because it requires you to do the work. He loves that line. Blanket policies are inherently reckless and lazy. The middle requires you look at each case individually. That's what I'm going to do. Deadline says, let's talk about a big individual case on your desk, the Menendez brothers. Hochman says, I knew that was coming. Deadline. I know you knew because you yourself have spoken about the brothers and the renewed interest in their case for several months now as momentum has accelerated for the re examination of their case, something your predecessor picked up on in the closing days of the campaign. Hochman says yes. Deadline says even before the election, even as then DA Gascon pressed ahead with resentencing recommendations and more, you said you weren't going to make any promises. You said that when you got here, you're going to look at the files and you're going to look at the cases. Just before Thanksgiving, even before you took office, Judge Michael Jessic pushed a previously scheduled resentencing hearing to the end of January as a courtesy towards you and your office to give you the time to decide what you wanted to do. So, where do things stand with the case of Erik and Lyle Menendez with you? Hochman says, first of all, the courtesy by Judge Jessic is much appreciated. Much appreciated. We have begun the process. I have begun the process. Deadline says, what has that entailed? Hochman. I've gotten access now to more and more of the files that were confidential, the transcripts from the actual trials. We're looking through the testimony as opposed to the highlights of testimony that people have been happy to share. We're looking at the law dealing with resentencing as well as the law dealing with the habeas situation. Do you know the difference? Deadline says, I do. Hochman says they're different. There can be different results depending on which way the law actually plays out. Once I get up to speed on my end, I'm going to call Mark Garagos, invite him to come in and make any level presentation he wants. I'll make the same offer to any victim family member if they want a personal audience with me. Funny because they did and you didn't. Deadline says a lot of the family have been quite vocal about seeing the brothers released after almost 30 years. It's been 35 years in prison, but it's no secret that family is divided. Hochman says, yes, I've spoken to the lawyer for the brother of Kitty Menendez, who has a different position. That's Kathleen Katie, who he's not really supposed to be talking to about this, who's supposed to be walled off, right? Or at least not at this point, but he says he's spoken to Kathleen Katie, who has a different opinion than the rest of the family, and they filed different paperwork for it. Anyway, at the end of it, we'll make the call because the resentencing law is somewhat unique for California and it operates on much different principles than most people really understand. In other words, that once this process is triggered by a DA's motion, because the defense can't trigger it on its own, then the judge gets enormous amounts of discretion on what the judge wants to do. Still has to look at the interests of justice, rehabilitation, gravity of the offense to begin with, different data points as the law has multiple factors, but it is still somewhat amorphous. Deadline. This may seem pedantic, but do you think we'd be talking about the Menendez brothers now if Ryan Murphy and Netflix hadn't made a hit show about them? Yes. Yes, we would because it's memorialized in court TV and all over and social media, and we would still be talking about the Menendez brothers because it's time for them to come home. But that's my answer. Hochman said this. That I don't know one or I'm assuming he means one way or the other. You'll have to talk to my predecessor about that. But here's where I like the attention. I like the attention in that, if people are focused on criminal justice issues, that is a net positive for our society. If it's the Menendez case that got them interested, or at least start exploring these different types of issues, then that's good. Deadline says, on that note, there's a big difference between campaigning and holding the office. So, with the knowledge of the reality out of there that many people in many different parts of the country feel, okay, now that you are in the DA's chair, what are the biggest challenges you have set for yourself? Hochman. Initial challenges is getting the two main drivers of criminal justice and enforcement back on track. Okay, I was just making sure that I was reading the right part because you stopped talking about uh, the Menendez brothers. Um, he says, this is my own office. Start with that. I mean, I'm entering an office that at one point voted 98% to support their boss's recall. That's almost unheard of. So these folks have been, again, enormously receptive to a newcomer, to someone who's basically said to them that the greatest asset of the DA's office is not the courtrooms, the cases, or the computers, but the prosecutors themselves. To me, the mission of the DA is to maximize the greatest asset, which is that. So I basically said, look, I have your back. You need training and you need resources, you need credit for the good work you've been doing. I can deliver on all that. Getting their trust back has been something that's been absolutely a day one project, and we're well on the way. You then need to convert that over to law enforcement because it's great to be able to prosecute the cases. But ultimately, the pipeline of getting cases to the DA's office is law enforcement, Deadline says. To that, one of the elements of the Menendez case is this notion that society has changed dramatically since the 1990s in our attitude and response to R and SA to men. There is a notion among some supporters of the brothers that with the assaults they allegedly suffered from their father and the role that played in their shotgun homicides of him and their mother, we would look at what happened differently today with a possible different outcome. What's your perspective on that historical curve? Hochman says, well, the changing values in society, certainly the changing technology that helps you do a better job of truly understanding who's guilty and who's not. I think it's a bit simplistic to say that society back in the 90s didn't recognize SA of young boys or men. I think it did. No, it did not. I think there's plenty of cases that this office and offices across the state were bringing to the courts. Not so much, buddy. It wasn't public, like, people didn't talk about that kind of thing. It was taboo to talk about. And when they did talk about it, you got made fun of. Like the Menendez brothers. You talk about SA as a boy, especially a male on male, father on son, they were made fun of. Just I can't find my words today. They were made fun of. I can't think of the word. They never stopped. It was endless. It was endless making fun of them, and they were put basically made to be the monsters and not victims as they actually are. Deadline says that's not the mantra you hear from Menendez lawyer Mark Garagos. Hochman says Mr. Garagos has been very happy to repeat that mantra, and the media has repeated Mr. Garagos's mantra. What I'm saying is that whether or not the mantra is actually true is that no one's actually looked, that I'm aware, to see what types of cases in the volume of cases that were brought were where the victims were young boys or young men. They make it seem like it never happened. I know for a fact it did. That's part of your question, which is the assumption that this was never prosecuted. So that the they were prosecuted, but regular lay people didn't understand it, is the problem. Yes, you might have had cases where you were prosecuting where this, wasn't a factor, where SA may have been a factor of the defendant's life, but ugh, he's just so crazy. He doesn't understand. Like, yes, you may be prosecuting it, but the world, society, the jurors don't understand the implications or the ramifications of SA. Still, people to this day don't understand it, which is why I'm trying to why I'm covering this case, because people still don't understand how SA or abuse of any kind can affect you psychologically, mentally, all of it can wear you down. Anyways, I'll finish or I'll start the sentence again. He says that's part one of your question, which is the assumption that this was never prosecuted, so that the social mores at the time is that it couldn't happen. Second assumption of your question is that in the second trial that the issue wasn't raised because again, that's Mr. Garagos's mantra, which the media has repeated. It may very well have been raised. However, their experts were limited in what they could talk about. Their experts probably weren't allowed to get into all of the effects that SA can have from a young child up until adulthood or, young man years like 18 to 21. I don't know, if they got into all that. We haven't gotten to the defense's case as we read through the 1996 trial transcript, but I'm already seeing a ton of differences in the way that this judge is acting and the way that he's ruling. So and we're only in the beginning of the state's case. Well, probably in the middle. All right. Next deadline says, it sounds like you view it as a battle on two fronts. Hochman says, do you know whether or not Erik Menendez testified in the second trial? Deadline says, off the top of my head, I do not. I believe he did. Hochman says he did for 7 days. Probably, if I had to guess, close to 40 hours of testimony where he went into great detail as he did in the first trial, incident by incident by incident between the ages, I think, of about 6 to 18 of what his father had done to him. Andy Cano, the cousin, he testified in the second trial for days also about the essay that was experienced by Erik that he was aware of. So the note, he didn't testify for 7 days about it. He only, his testimony about that was probably very brief. But yes, Andy Cano may have testified for several days, but his testimony about his conversations with Erik about it were brief, I'm sure. Anyways, so the notion, again, the mantra that SA wasn't explored in the second trial, that the judge kept out all of the evidence, actually isn't true. No one's saying that he kept out all of the evidence. We're saying they were severely limited. Deadline says, so why do you think that has become so accepted then? Hochman says, I mean, I've been doing this for 35 years. I've seen it. The media is in search of simple narratives, conflicting narratives, and so it adopted the Garagos narrative, which was very smart, very creative. It's basically that the trial was all about SA, that their response was because of SA. It's that a conviction was only attained because the evidence of a essay didn't occur in the second trial, but occurred in the first trial, and therefore that was the underlying conviction is wrong and should be fixed. Very simple narrative. What makes it a little bit more complicated, and that's why the media would have to do additional work. No offense to your profession. Deadline says, that's okay. My profession is the enemy of the people in some circles, like yours is in some other circles. So your criticism is just fine. Okay, kiss his ass a little bit more. With the perspective you've outlined, how will you approach looking at this case? Hochman says, knowing the Garagos narrative is absolutely wrong, the issues that we'll be looking at for the trial will be whether or not the these two young men faced an immediate threat to their life. Why they got to that point, how they got to the point is irrelevant for the trial. For the convictions, maybe not irrelevant. By the way, certainly for resentencing, and it actually plays a different role in resentencing. As I said, Erik Menendez was able to testify in great detail about all the essay he experienced. He was even able to testify about essay that Lyle experienced. He was even able to testify about the fact that Lyle purportedly confronted his father, their father, about this whole issue, which is why they had some level of fear that the father was going to take their lives. So you just admitted that that is why. Oops, I didn't mean to cross that out. I meant to highlight that. So basically, yes, it is. He agreed. Well, I guess he's saying that that's what he testified to, not that he believes it. All right. I'll give him an out on that one. All right. All that was presented to the jury, and the jury still convicted them both of first-degree homicide. Deadline says, heading towards next month's resentencing hearing, what are you preparing right now? Hochman says, well, ultimately, the resentencing law allows rehabilitation to come into a mix, so it's not just whether or not the underlying crime was proven and sustained on appeal and all that. You know, are entering in the concept of rehabilitation and the interests of justice on top of that. And you do this with a fairly vague standard that doesn't give judges particular guidance on how to evaluate all these factors, only to figure out whether or not someone is a threat to society, poses a danger to society, and otherwise has been rehabilitated. So, and it's somewhat California unique in that respect. So, we're going to go through all of the evidence and weigh all the factors and ultimately come to the judge and say to the judge, here's all the records, here are your options, and make sure that whatever decision is ultimately made in the best informed decision possible. And then it goes into other topics. They start talking about the Weinstein trial and Trump and immigration and stuff, which I don't care about in this channel. So we'll move on to the next exhibit that I want to bring to your attention, which is the legal policies manual. This is the updated version that Nathan Hochman himself signed into effect. on December 3rd. The Los Angeles County District Attorney's Office Legal Policies Manual, in effect on December 6th, 2020, is hereby restored, replacing and abrogating the LPM in effect through this date. An electronic version of the restored LPM is available on LADA.net. The restored LPM has been revised to reflect developments in the law between December 2020 and December 2024. The LPM will continue to be updated periodically as new policies are implemented, modifications are made to the organizational structure of the office, and to reflect evolving changes in the law. Significant revisions to the LPM will be announced in forthcoming special directives. Continuing familiarity with policies set forth in the LPM and close adherence to these policies is critical to the mission of our office, dedication to the fair and ethical pursuit of justice. So he's saying that these things matter, but he's not doing the same. Consistent with that overriding concern, if a deputy believes that application of a policy or directive included in the LPM would result in an injustice, the deputy is to inform a supervisor so the matter at issue can be reviewed. So that was just like a memo, but I'm assuming that there was more on that policy that they distributed internally. Um, all right, next is. Oh, yeah, I was on the right one. I'm skipping around some of them. They're not as compelling. So this this is an article that was written by Kathleen Cady about George Gascon in October of last year. So it says guest opinion Kathleen Cady. George Gascon must be fired for his incompetence, mismanagement, and betrayal of justice. When violent crime strikes, victims need swift justice and meaningful support to begin their path to healing. Yet, for the past 4 years, this is while an election's going on, by the way. Yet, for the past 4 years, George Gascon has done nothing but undermine the very foundation of justice in Los Angeles County. His policies have not only devastated victims, but have shattered entire communities, leaving behind a wreckage that is both heartbreaking and inexcusable. Gascon has failed every day on the job, and the victims are paying the price. While Gascon boasts that victim service representatives, advocates, in his Bureau of Victim Services are ready to help, this couldn't be further from the truth. For more than 40 years, these advocates have been essential in guiding victims through the criminal justice system, offering them support and helping them heal. But no amount of resources or dedication from these tireless advocates can undo the damage inflicted by Gascon's reckless policies. Gascon's incompetence has only worsened the situation, leading to a tragic decline in available services for those who need it most. In the last year alone, due to Gascon's gross mismanagement, his office lost 3 vital grants, leading to the elimination of 7 advocate positions. These advocates were responsible for assisting victims of human trafficking, gang violence, and elder abuse, those who are among the most vulnerable in our society. Gascon's policies prevent prosecutors from filing gang related charges or seeking bail for human traffickers or elder abusers. Um, and his incompetence has now gutted the very resources that could support these victims. Because of Gascon's failures, these victims face an uphill battle for justice and must do so with fewer resources and support than ever before. And it gets worse. The district attorney's office, under Gascon's leadership, controls an unclaimed restitution fund intended to provide financial support to victims in desperate need. These funds could be used to pay for necessities like food and shelter for victims of violent crime or medical equipment for elder abuse victims. But instead of safeguarding these precious resources for those who truly need them, Gascon wanted to change the very definition of victim to include anyone he personally deems deserving without any oversight or approval from the Board of Supervisors. Thankfully, this reckless plan was halted when the DA's office realized it could trigger yet another audit, but the fact that Gascon even considered it shows his utter disregard for the victims he's supposed to serve. She's angry. I can sense her anger in this. She doesn't like him. It's no surprise that under Gascon's watch, I don't know if any of this is true or not. I can't vouch for any of it. I just know that this is an article she wrote. No surprise that under Gascon's watch, the resources meant for victims are dwindling. There are fewer than 50 advocates in all of Los Angeles County to serve victims of violent crime, from homicide to human trafficking and elder abuse. Yet, despite this critical shortage, Gascon tried to implement a policy that would have diverted these advocates to assist families of individuals who died in confrontations with law enforcement or while in custody, people who are not victims in the traditional sense. One such case involved a man who was shot by police after refusing to drop his gun while threatening four innocent people. Another involved a person who died of cirrhosis while in custody. These are not the victims that the BVS was established to help. Gascon's insistence on treating them as such only further undermines the advocate's ability to support actual victims of crime. The bottom line is clear. George Gascon abandoned the people he swore to protect. His mismanagement and incompetence have stripped away crucial resources, leaving victims with little support in their darkest hours. Gascon must be fired. The people of Los Angeles deserve a district attorney who values justice, stands up for victims, and will restore safety and sanity to our communities. Nathan Hochman is the leader we need to bring the justice back. It's time for Gascon to go. The next exhibit I want to show you is a formal complaint regarding a violation of victims' rights in the Menendez case proceedings. This is from Tamara Goodell. She's the cousin of the brothers. She says, or in this letter, it says, Dear, who's writing it? I'm not sure who's. Yeah, it is in Tamara's first person point of view. All right, so Dear United States Attorney's Office, Civil Division, out of fear of retaliatory consequences, I have been refraining on filing any sort of communication regarding the disappointing and traumatizing treatment my family and I have received from the newest administration in the Los Angeles District Attorney's Office. However, after Nathan Hochman's most recent press conference, I am writing to formally lodge a complaint regarding violations of my rights as a victim under Marcy's Law, as codified in the California Constitution, Article 1, Section 28, during the hearings related to the Menendez case. My family and I have been victimized twice. First, by the horrific events involving Joseph Lyle Menendez and Erik Galen Menendez on August 20th, 1989, and now by the treatment we have received throughout these proceedings. For the past 35 years, we have endured profound stress, anxiety, and depression while seeking justice, all while learning of the horrific emotional, physical, and SA, including childhood R, that Lyle and Erik suffered at the hands of their parents. The LADA's violation of Marcy's Law during the larger family meeting on January 2nd, 2025. During the joint session attended by 20 plus family members and District Attorney Nathan Hochman, our rights as victims were blatantly violated. In a tear filled meeting, numerous family members shared the ongoing trauma and suffering we have endured for more than 30 years. Instead of responding with compassion, acknowledgement, or support, DA Hochman proceeded to verbally and emotionally re traumatize the family by shaming us for allegedly not listening to his public press briefings. His hostile, dismissive, and patronizing tone created an intimidating and bullying atmosphere, leaving us, the victims, more distressed and feeling humiliated. Rather than focusing on the trauma and concerns expressed by the family, DA Hochman, excuse me, sorry, I had a tickle in my throat. I didn't want to cough on camera. DA Hochman shifted the meeting's focus onto himself, making it a lecture on how he was being personally treated rather than an opportunity to hear and respect the voices of the victims. So he made it all about himself and how people were treating him at that meeting. The lack of compassion was palpable, and the family left feeling not only ignored but further intimidated and re victimized. As the LADA is aware, the California Constitution, Article 1, Section 28B states, in order to preserve and protect a victim's rights to justice and due process, a victim shall be entitled to the following rights. 1. To be treated with fairness and respect for his or her privacy and dignity, and to be free from intimidation, harassment, and abuse throughout the criminal or juvenile justice process. DA Hochman's dismissive, aggressive, and shaming behavior was a direct violation of these fundamental rights, further deepening the trauma my family has endured for decades. LADA's violation of Marcy's Law during a small group conference on January 3rd, 2024. Immediately following the large family meetings with the LADA and team on January 3rd, 2024, I, along with my son Lucian Goodell, attended a private meeting with Mark Garagos, Brian Friedman, Nathan Hochman, Stephen Katz, Seth Carmack, and Ethan Milius. I left this meeting feeling completely disregarded and disrespected as a victim. My rights under Victims' Rights 1, 4, and 9 of Marcy's Law were once again blatantly violated as outlined below. Number 1. Right to justice and due process. Right 1. My right to be treated with fairness, dignity, and respect for my privacy and well being was not upheld during this meeting. While I was attempting to raise concerns about the Los Angeles District Attorney's Office's ability to remain impartial, Mr. Hochman became visibly agitated, dismissive, and aggressive. When I brought up the potential conflict of interest regarding the appointment of Kathy Cady as director of the Bureau of Victim Services, he interrupted me, speaking in a condescending and hostile manner. So he just cut her off and started talking to her, like yelling at her, berating her. Instead of addressing my legitimate concerns, Mr. Hochman aggressively pressed me, questioning what I knew about Kathy Cady's prior work. Like, why is he so defensive of her? Mr. Hochman then accused me and my family of lambasting Kathy Cady in the media. When I clarified that I had not done so, he responded, I may be looking at you, but my comments are directed at others in the room. His accusatory and hostile demeanor further reinforced his bias against my family and our legal representatives. At one point, Mr. Hochman even made an unprofessional and prejudicial statement commenting that Mr. Garagos has represented horrible people. This inappropriate remark reinforced his bias and made it clear that he cannot act objectively in this case. Perhaps most disturbingly, my son was present during the entire exchange. He witnessed firsthand Mr. Hochman's abusive, belittling, and unprofessional conduct, further compounding the emotional toll on our family. That sucks. Like, why are you yelling at her in front of her son? When I expressed my deep discomfort with Kathy Cady's involvement, given her previous representation of Milton Anderson, the only family member opposed to resentencing for Erik and Lyle, Mr. Hochman coldly dismissed me, stating I was welcome to refuse the assistance provided by her office. Like, well, you don't have to use her services then. You don't like her, you don't have to use her services. He offered no alternative support, effectively denying my right to unbiased victim services. What a child he is. I mean, seriously, you don't like a little criticism from some people that, have your decisions have an impact on? You don't like their criticism, yet you can go all over the news and say all the garbage things you want about the case. But no criticism for him. We're not supposed to criticize him, guys. Number 2, right to prevent disclosure of confidential records. Right 4. My right to prevent the disclosure of confidential records, communications, or privileged information was violated. Kathy Cady, the director of the Bureau of Victim Services, previously represented Milton Anderson gaining access to confidential family information. I'm going to highlight that part there. So, despite this clear conflict of interest, she was not removed from this case. I wonder what was disclosed to her, but that sucks. Clearly there's a conflict of interest. She should not be getting information about this part of the family if it's going to be, you know, conflicting. On or around December 15th, 2023, Mr. Hochman met privately with Kathy Cady and Milton Anderson weeks before meeting with the 20 plus family members who support resentencing. This compromised victim confidentiality and raises quite serious concerns regarding violations of Marcy's law, of privacy under Marcy's law. Number 3, the right to a speedy trial and prompt conclusion of proceedings. Right number 9, my right to a speedy trial and prompt conclusion of proceedings has not been respected. Since October 2024, there have been 3 delays in judgment and proceedings. The original writ of habeas corpus was filed on May 3rd, 2023, yet my family continues to experience delay after delay. These continuous delays have inflicted severe emotional and psychological distress, prolonging the pain we have endured for 35 years. Request for action. Given the clear violations outlined above, I formally request the following actions. Number 1, Kathy Cady be permanently removed from any involvement in this case due to her conflict of interest. 2, a new unbiased representative be assigned to handle victim services for my family. 3, Nathan Hochman be held accountable for his outrageous and abusive behavior, particularly his aggressive and dismissive conduct in front of my son. 4, Mr. Hochman be removed from the case, and the case be transferred to the Attorney General's office to ensure fairness and impartiality. So here she's asking for it to be moved as well. Do we have a date on this letter? Sorry, guys. This is just March 6th. Okay, so this is pretty recent that they wrote this, but it was before the motion to recuse. So even before they asked for the recusal, she was already asking the Attorney General to take over this case. Mr. Huckman's behavior during the January 3rd meeting and the larger family meeting was not only inappropriate but outright abusive. His conduct has caused significant emotional distress and eroded any remaining trust in the LADA's office. I expect this matter to be taken seriously and for immediate action to be taken to address these violations. Thank you for your time and attention to this urgent issue. Please feel free to contact me. And there you have it. They should have redacted that, but oh well. Here is, I didn't want to show that. What's next? Oh, here is, I'm not going to read it all, but here is just for reference, the page of Justice for Children whose lives had been taken. Can't say the M word on YouTube. Was established in 1996 by LaWanda Hawkins. LaWanda's profound motivation came from the tragic loss of her son. Okay, so there's a whole long, story. But they're just giving it as, an example. She is also, though, Kathy Cady is on the board of directors, by the way. So that's what this is showing. She is the attorney and she is on the board of directors. Next, I wanted to show you guys a declaration from Anna Maria Baralt, the other cousin who is also very vocal about the Menendez brothers' release. She says, I, Anna Maria Baralt, declare Jose and Kitty Menendez were my aunt and uncle. My mother is Teresita Baralt, who was Uncle Jose's older sister. I have become a de facto spokesperson and organizer of our family in connection with the potential resentencing of my cousins Erik and Lyle. On October 16th, 2024, I was with a group of family members that met with representatives of the DA's office. There were A number of members from the DA's Department of Victim Services. Celia Zamora was one. She introduced herself to us and urged any of us to reach out with any questions. She made clear that Victim Services was there to support us in a wide ranging capacity from answering questions to facilitating resources for travel. We were told that Victim Services would be available to us during any proceedings. On October 24th, 2024, the DA held a press conference to announce he would be seeking resentencing in the case. I was once again with a number of family members who attended the press conference. Once again, we were assisted by victim services representatives, including Ms. Zamora, both before and after the actual press conference. They answered any questions and made sure we were comfortable, in some cases as simple as bringing us water, as we were very nervous. On January 3rd, 2025, after the November election, I was with a group of family members that met with the newly elected district attorney, along with several other lawyers from his office. No victim services representatives met us, and no one from victim services offered us any assistance or support. There were court hearings in the case on April 11th and April 17th. I was with a number of family members that attended these hearings. Once again, no one from Victim Services was there to support or assist us, and no one from Victim Services ever alerted us to the hearings or to the fact that the prosecution had moved for a continuance on April 16th. I declare under penalty of perjury that the foregoing is true to the best of my knowledge and belief. Executed on the 24th day of April in Washington, and that is Anna Maria Baralt's, whatchamacallit, what is this? Oh, I'm not going to read through that one. This is in another case, but this was Kathy Katie was basically trying to disqualify George Gascon from, is he trying to, yeah, he was trying. Kathy Katie tried to disqualify George Gascon from another case, and this was the filing on that, basically saying all the horrible things George Gascon has done. So you can see her bias, but I'm not going to read that one. Let's see. This is the continuation of that policy, the L, the legal policies manual. So, this is a letter from Jackie Lacey, whoever that is. She's a district attorney. She says, I am pleased to introduce the revised County of Los Angeles District Attorney Legal Policies Manual. Revisions to this manual were necessary to ensure that the latest policies were available to guide you on the successful prosecution of cases. As this manual is both important and informative, please take time to review and understand how its components impacts your daily caseload and how crucial decisions for handling cases should be made in this office. Because the law is not static and policies are updated regularly, this manual is a living document that will be periodically modified. Basically, so the thing is living, breathing document. I'm not going to keep reading. It's really not relevant to us. I thought there might be some more information about what policy. Oh, here's the parts that's changed. That's the important part. Communications with victims and witnesses. All witnesses are entitled to be treated with dignity, respect, courtesy, sensitivity. Navigating through the complicated maze of the criminal justice system and the courthouse environment may be confusing for civilian witnesses. Deputies shall be sensitive to the concerns of victims and their families in all cases. Deputies shall be especially sensitive to the emotional needs and problems of families of homicide victims, as well as intimate crimes and DV victims. Keeping victims or their next of kin informed of case developments and addressing their concerns is paramount. So, already in this first, I haven't even finished the first paragraph, and we can see that Nathan Hochman has disregarded most of everything that just was said. The experience of being a witness and all that it entails is a challenging one under the best of circumstances. Victims' rights shall be honored and protected by prosecutors in a manner no less vigorous than the protections afforded to criminal defendants. Deputies should refer victims to the Bureau of Victim Services for available services. BVS offices are located at the Fultz Criminal Justice Center and various locations throughout the county. A victim services representative should be notified immediately upon the filing of all homicide cases and other sensitive cases, such as those involving SA, DV, gang violence, hate crimes, and crimes involving elderly or very young victims. Proposition 9, otherwise known as Marcy's Law, amended Article 128 of the California Constitution enumerating crime victims' rights, the safety and security of all Californians including victims, is a top priority for the office. Communicating rights and obligations, clear and consistent lines of communication must be established with victims. Marcy's Law Victims Notifications. It is the policy of this office that all victims who have suffered direct or threatened physical or financial harm shall be notified of their Marcy's Law rights in all felony, misdemeanor, and juvenile filings. Office personnel responsibilities. For responsibilities of employees at the time of filing, see Legal Policies Manual 2.13. Victim Services representatives in offices that have a full-time VSR, the VSR is responsible for forwarding all victims' rights request forms received via fax and U.S. mail to the assigned deputy. Restitution Enhancement Program paralegals are placed in offices throughout the county. Program paralegals will assist deputies with any type of restitution problems, regardless of whether the case is a felony or a misdemeanor. Program paralegals will assist by contacting victims to obtain loss documents, by obtaining statements of loss through the use of the victim restitution request form already in use in the instance where the victim has not provided that form, and by providing general assistance with regard to any restitution issue. Program paralegals will also assist deputies when monetary assistance has been provided to the victim through the victim's compensation board and the board is seeking to recover monies from the defendant following conviction. Assigned deputy. The assigned deputy is responsible to advise the court when a victim has requested one, to have, quote, my safety and the safety of my family considered in setting bail for the defendant. 2, to be present at the proceedings. 3, to be heard at the proceedings. 4, to make a statement to be considered at the time of a sentencing. Or 5, restitution. In cases in which the victim is requesting restitution, the assigned deputy shall determine whether assistance is needed by the restitution enhancement program and may refer the case to a restitution paralegal for the purpose of determining the amount of restitution, gathering proof, blah, blah, blah. This is all long legalese. Gathering proof of loss documents and contacting the victim regarding restitution related issues. All employees. In the event a victim or next of kin contacts the local district attorney's office, the employee who spoke with the victim shall 1. Ensure that the pertinent parts of the conversation are recorded in the DA's file. This can be accomplished by either writing directly in the notes section in the DA's file or by electing to use the Marcy's Law victim intake form and providing the completed form to the assigned deputy to place in section A6 in the DA file. 2. Update the PIMS to enter the victim in PIMS, whatever that is, when the victim is requesting notification of upcoming court dates or deposition. And 3. Prominently mark the outside of the DA file with a Marcy's Law stamp. Each step is critical to ensure that successively assigned prosecutors are knowledgeable about any specific request with respect to the victim's exercise of their right. This is a lot of long legalese, and my tongue is tired. Probation, mandatory supervision, violations, parole hearings, certificates of rehabilitation, pardon, and other post-conviction hearings. Victims, upon request, have a right to reasonable notice and to be present and heard at all public proceedings involving post arrest release decision, sentencing, post conviction release decision, and any proceedings in which a right of the victim is at issue. So this is the stage in which we're at with the Menendez brothers, obviously. So when a victim has requested his or her Marcy's Law rights and the defendant subsequently violates probation, mandatory supervision, or there is a public proceeding in which a right of the victim is at issue, every reasonable effort must be made to notify the victim of the hearing to allow the victim an opportunity to be present and be heard. It is the responsibility of the assigned deputy to check the DA file and or PIMS to determine whether a victim has requested this notification and then provide notification of the hearing or proceeding. So basically, they didn't do that either because they didn't they've not that they didn't notify them of the hearings. They were heard, they were there, but they showed these photos that they didn't warn them about, and they absolutely should have. So that is a violation. Victims' right to be reasonably protected. Victims have a constitutional right to be reasonably protected from the defendant and persons acting on the defendant's behalf, and to have their safety and the safety of their family considered in setting bail and release conditions. All employees are reminded that thorough and timely communication between all members of the prosecution team is essential in the pursuit of justice in all cases. It is vital that open and active lines of communication exist between law enforcement, victim services representatives, support staff, and attorney staff. While this is particularly true in VIP category cases, it is an important aspect in every case we prosecute. It is essential that any employee who learns that a victim or witness is expressing fear or has personal safety concerns. What if your safety concerns are from the DA? Immediately notify the assigned deputy in writing with a summary of the conversation and copy of the prosecutor's supervisor, head deputy, and or the deputy in charge. In the event the victim's safety concern is communicated to a filing or handling deputy, appropriate notation shall be made in the file along with any protective measures taken or suggested. The employee may elect to use the victim's exercise of Marcy's Law rights intake form and give the completed form to the assigned deputy to be placed in the file in lieu of making notations directly in the file. The victim's right to respect for privacy and dignity. Victims have a right to be treated with fairness and respect for his or her privacy and dignity, and to be free from intimidation, harassment, and abuse throughout the criminal or juvenile justice process. District attorney personnel shall be mindful of a victim's right to respect for their privacy and dignity at all stages of the criminal justice process. This includes the decision to maintain the anonymity of the victim's name in court proceedings and on any document submitted to the court. The deputy, upon request of the victim, may enforce a victim's constitutional rights when they are not inconsistent with our mission of the law. District attorney personnel should take protective measures to prevent the insensitive handling, dissemination, and retention of victims' private documents, photos, and personal mementos. So that comes to light with the photos that they displayed at the hearing. It is our responsibility that when victims and witnesses participate in the criminal justice system, they are not caused undue emotional trauma, harassment, or embarrassment. Examples include the disclosure of confidential information or the unnecessary dissemination of distressing photos or physical evidence. With the advent of the internet, posted information can never truly be recalled or retracted. When disclosure or confidential information is necessary, it is our responsibility to ensure that the information is sufficiently protected with appropriate protective orders. Protection of sensitive documentary records. Prosecution of criminal cases may involve documentary records that are sensitive in nature that victims may want protected. Examples of sensitive information are medical records, photos of victims' injuries, including SA photos, psychological records, financial information, and other sensitive records. And we know that Kitty was seeing a therapist, so there's psychological records in this case, medical records for the brothers, therapist records for them, injuries of victims, obviously, of Kitty and Jose. When these types of records are entered into evidence, they are presumed to be open unless confidentiality is required by law. When feasible, the victim should be contacted and advised before sensitive documents are made public in court and before such documents subpoenaed to the court by the defense are reviewed in camera or opened in court. As prosecutors, we can only act on the request of a victim in this regard to the extent that we can maintain our ethical obligations in prosecutorial independence and discretion. If the prosecution's interests are different from or are otherwise in conflict with the victim's privacy interests, the victim may wish to retain a private attorney to represent their interests in the matter to prevent the disclosure of his or her otherwise confidential or personal information. Ultimately, when the victim's rights to privacy conflicts with the people's or the defendant's right to due process and fair administration of justice, best practice is to request an in camera hearing for the court to decide whether disclosure is required and, if so, the protective measures to be ordered to minimize damage to the victim's rights to privacy. There are specific methods a prosecutor can use to protect sensitive documentary information, such as photos which depict injuries, photos of genital or other private areas, medical records, financial records, employment or school records, psychological records, or cell phone records from public disclosure. Images of uh, C rhymes with corn may only be disclosed pursuant to the provisions set forth in Penal Code, whatever. The following is a description of methods that can be employed to protect the victim's right to respect for their privacy, both during and after the prosecution of a criminal matter. Protective orders. When considering whether medical records, including genital photos, should be disclosed, the court must weigh the public interest and the need for disclosure against the injury to the patient, to the physician patient relationship, and to the treatment services. If the court allows disclosure of the medical information, disclosure and dissemination shall be limited by a court order to assure that no information will be unnecessarily disclosed and that dissemination will be no wider than necessary. A protective order can be used during the pendency of the case and following its close to ensure that defense attorneys do not disclose medical records. Sealing records pursuant to California uh, code. California rules state that the court may order that a record be filed under seal only if it expressly finds facts that establish that there exists an overriding interest that becomes the right of public access to the record. The overriding interest supports sealing the record. A substantial probability exists that the overriding interest will be prejudiced if the record is not sealed. The proposed sealing is narrowly tailored and no less restrictive. Okay, well, we don't care about sealing records, right? That's not really the issue here. Victims' right to privacy and dignity, anonymity. Several statutes protect victims of DVSA. Okay, so we don't need anonymity because we know who the victims are here. The victim's right to respect and dignity, general. Victims, witnesses, experts, and law enforcement personnel are often brought into district attorney's offices for interviews while waiting to go to court or in preparation for testimony. The environment that victims see when coming to a district attorney's office must also reflect respect for their privacy and dignity as human beings. Evidence from cases, especially gruesome crime scene photos or photos of victims, should not be displayed on walls or left openly displayed for anyone to view. Such pictures or other evidence out of the public view may cause the victim or witness discomfort or give the impression that our office does not safeguard all victims' rights to privacy. Um, nope, not that. Well, let's see. I think I had one more. Oh, this was it. This is an article, some of it gets cut off because it's on the same, it's like the Daily Wire So this is an article from the Daily Wire that says Deputy DA says George Gascon's Menendez resentencing decision is just a political ploy. I don't know why it's on this other page like that, but that's how it came out. So there, it's an article about this guy Lewin, John Lewin, who is another attorney in the DA's office who also got a promotion. So I can't read it all, so I'm going to start here. Lewin goes on to explain how the days before Gascon announced he was going to have another look at the Menendez case, there was a story in the LA Times discussing how he had refused to prosecute a juvenile double homicide suspect who subsequently went on to commit homicide again. The deputy DA also mentioned that even if the Menendez brothers were essayed by their father, as they claimed, it wouldn't be justification for homicide. They executed their parents, basically blew them apart with shotguns. They ended up spending a bunch of money and they opened the safe the next morning because they were very worried that there was a will. That's according to Lewin. Lewin called the resentencing recommendation a publicity stunt. George Gascon has 1,500 unfiled cases, including a bunch of uh, cases of the intimate kind that he's not paying attention to at all because they don't generate publicity. This is a publicity stunt designed to basically bait and switch the electorate. So now so definitely I think Hochman is using this as a political ploy, but they accused George Gascon as well of doing the same thing. So whether he was or wasn't, I have no idea. I don't think so because it wasn't even him that brought this up. It was two attorneys that were in his office who were just doing their jobs of going through resentencing, and their case came up, and that's what happened. The next court date for the Menendez brothers, okay, so that was slated for November 26th when that was written. So that is all I have for you guys regarding the oh, those are some posts and stuff. There's a lot of articles and things in this. I just don't want to read them all. There are other things that Lewin has said and done. Um, does this talk about his promotion? Let me see. LA prosecutor suing over alleged demotion during Gascon era. So somebody else during Gascon's era, somebody was demoted. Deputy District Attorney John Lewin's attorneys filed court papers with Los Angeles Superior Court Judge Steve Cotrain on Tuesday, notifying him of the conditional accord with the expectation that a request for dismissal be filed. So John Lewin is the one that is saying that he was demoted for speaking out against George Gascon. So maybe he's got some retaliation in mind about this. He was also awarded a Distinguished Achievement Award in 2021 for his 27 years of service. I don't know. I'm not reading it all, but there you go. There's some little snippets. Lewin was the lead prosecutor in the trial of the Robert Durst case. Oh, a New York real estate heir who was serving life in prison without parole, who died in January 2022 at the age of 78 of natural causes. Durst was convicted in September 2021 of first-degree homicide of Susan Berman, his friend Susan Berman. There were others that he also allegedly took the lives of. Former, former federal prosecutor Nathan Hochman unseated Gascon, as we know, in the November 5th elections, and that's where this all stems from. George Gascon losing and Nathan Hochman taking over and becoming just tyrannical in his search for, or not even search, his efforts in trying to keep the brothers incarcerated, which just makes no sense to me. I don't understand what his deal is, what he has really put, why is it so important to him? He's got such an interest in it, and I don't understand. He's so passionate about how awful the brothers are. All right, so that is what I have for you. You guys, let me know. Oh, by the way, I know it came out in one of the interviews. Mark Garagos had said that Nathan Hochman went to high school with the brothers. I don't know what year, if they were separated by years. I'm assuming, but he went to the same high school as the brothers did. So he went to Beverly Hills. He knew the people. He knew the area. Like he's got the whole like local lore about it. He's local. He's been there his whole life. So maybe that's why he's got some kind of something up his butt about it. I don't know. But there you have it. And I will try to get the response to you from Nathan Hochman to you guys shortly. Hopefully before Friday. So thank you guys for watching. Please be sure to like, subscribe, do all the YouTube things, and I will see you guys in the next video. Thank you again. Take care. Bye now.